will discuss the questions and answers regarding the contract of indemnity. So, question number one, define a contract of indemnity, state the rights of an indemnity holder and when he is sued. So, section 124 of the Indian Contract Act 1872 defines contract of indemnity as a contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. So, it is called the contract of indemnity. And as regarding an illustration, the owner of a commercial property has been paying an insurance premium to an insurance company so that she can recover the costs of any loss or damage if a future bad event were to happen to the very establishment. So, it is a kind of security or protection against a financial liability where one party agrees to pay for losses or damages suffered by the other party. Indemnification may be compensated in the form of cash by way of repairs or replacement or by other means which the parties have agreed upon. And the very contract of indemnity could be categorized as express indemnity or implied indemnity. And regarding express indemnity, it is a written agreement to indemnify, and such contracts are insurance contracts, construction contracts, agency contracts, etc. Whereas in implied indemnity, it arises from the very circumstances or conduct of the parties involved. So, a contract of indemnity is a direct engagement between two parties whereby one promises to save another harmless from the result of the conduct of the promisor himself of or of any third person. In other words, a contract of indemnity is a promise to become liable for a debt whenever the person for whom the promise is made should become liable, and the very consideration in a contract of indemnity and its objects must be lawful. So, the very contract of indemnity where a person may undertake to save the other from loss caused to him by the conduct of a third person, either at the request of the third person or without any request from such third person. And in case the first one, there would be a contract of guarantee and the third person would be responsible to the surety. In the latter case, there would be a contract of indemnity, and in a contract of indemnity, the indemnifier cannot, on non-performance of the obligation of third person, for example, a debtor in the absence of an assignment from the creditor sue in his own name the debtor, as there is no privity of contract between them, and regarding the very consideration or object of an agreement must of course be lawful. Thus, an agreement to indemnify the printer or publisher of a libel by the writer of the same cannot be legally enforced. Similarly, an agreement to an accused person or any other person to indemnify the person who has given bail is illegal and cannot be enforced. And now we'll discuss section 125, which provides the rights of indemnity holder. So, regarding that, the rights conferred upon an indemnity holder by this section are based upon an essential condition that he must be acting within the scope of his authority. And this is clear from the principal part of the section. This aspect is further emphasized by subsection 1 and subsection 2 and subsection 3 of section 125. So, subsection 1 requires that the suit must be in respect to any matter to which the promise to indemnity applies, while subsection 2 and 3 also states that in bringing or defending or compromising such suit, the indemnity holder should have been either authorized by the promisee or he did not contravene the orders of the promisor, or in absence of such authority or orders, his acts should be acts of a prudent man. So, it is only when an indemnity holder has complied with the said conditions that he would be entitled to recover from the promisor all damages and costs which he has been compelled to pay in such suit. And subsection contemplates that at each stage the indemnity holder applies for authority or orders of the promisor. The indemnity holder has to act as a prudent man. So the provisions of this section 125 deal with the rights of an indemnity holder in the event of being sued, and it is by means exhaustive of the rights of an indemnity holder who has other rights besides those mentioned in this section, even before damage is incurred by the an indemnity holder. So it would be open to him to sue for specific performance of the contract of indemnity, provided it is shown that as absolute liability has been incurred and the liability is covered by the very contract of indemnity. So, a contract or a bond by scholar to reimburse the government if he failed to return to India from San Francisco after completing his studies and then served the government for 5 years could be a contract of indemnity, and the scholar is bound to reimburse the government in the event of his failure to comply with the conditions of bond. And besides that, we'll discuss regarding the very commencement of indemnifiers liability, and regarding that we'll discuss certain important leading cases. So whenever it is the very commencement of indemnifiers liability, there is a distinct opinion between the different high courts as to when the indemnifiers liability is concerned. So, when it commences, the high courts of Calcutta, Madras, Allahabad, and Patna have taken the view that when a person contracts to indemnify another, the latter may compel the indemnifier to place him in a position to meet the liability that may be cast upon him without waiting until he, the indemnifier holder, has actually discharged it. The High Courts of Bombay, Lahore, and Nagpur have, however, taken the view that the indemnifier does not become liable until the indemnified has incurred an actual loss. So it is submitted that the former view appears to be more correct and is in consonance with the English law. So, in that connection, we'll discuss regarding the very important leading case Syntax India Limited versus Benmore Impacts Inc. and others. In 1986, the Calcutta High Court expressed whether it is a bank guarantee or a letter of credit or contract of indemnity. The enforceability of such an instrument against the bank depends on the terms and conditions of the same. The question before the court is in such a case is whether the terms of the same have been fulfilled to enable the beneficiary to enforce the same against the bank executing the same. In respect of such instrument executed by a bank, the bank is not and should not be concerned with the underlying contract between the buyer and seller. Duties of a bank under any such instrument are created by the document itself, but in any case, it has the power and is subject to the limitations which are given or imposed by it. The dispute as to sufficiency of the performance between the buyer and the seller or between the seller and the buyer cannot be the reasons for withholding the payment claimed under the instrument as it was expressed by their lordship in the very decision Syntax India Limited versus Benmore Impacts Inc. and others in 1986 by the Calcutta High Court. And in our upcoming video, we'll discuss some of the most important leading cases which fall under the very contract of indemnity and as they were disposed by the courts such as by the Calcutta High Court or Allahabad or Bombay High Court, even by the Supreme Court, and in that connection, we would like to discuss all these leading cases in our upcoming video.